Good afternoon, ladies and gentlemen. Sawadee-krap. I'm Jonathan Leeds. I'm going to be the first speaker today. Attorney from Texas, my older brother, Joe Leeds. I've been working in Thailand for 20 years, primarily as a consultant and a lecturer and managing a law firm here. And prior to that, I was in the state of Hawaii where I was a practicing attorney. I'm still actively licensed there. And my specialty is and was U.S. criminal defense law. What I'm going to try to do today is I'm going to try to present various general principles that are overriding principles of the U.S. criminal justice system and how they relate to the U.S. Constitution. The U.S. Constitution has a very central role in the U.S. jurisprudence system as well as the criminal justice system. And my objective is to try to provide a broad introduction for Mr. Stuart Leeds' presentation, which will be a bit more technical than mine. He's currently an attorney actively engaged in criminal trials in the United States. He's just completed a big criminal trial, which he successfully won. He's a very prominent attorney in the state of Texas. And to get started, I have my lecture presented in a series of sections, 6 sections. And I'm not able to cover all the ways that the U.S. Constitution relates to the criminal justice system because such a lecture would take a great deal of time. After each section, I'm going to pause and allow the Thai translator to summarize it and present the major points in Thai language. And I think we're going to have a discussion section, a session afterwards, which will involve questions and answers. So I'm looking forward to the presentation and the discussion today. To get started, since I've been involved in the legal system here in Thailand as a consultant, as a translator, for many, many years, almost 2 decades, I'm familiar with it to some degree. And I think it's important to contrast the U.S. criminal justice system with my own knowledge of the Thai criminal justice system. In certain ways, they're very similar, but in other ways, they're very, very different. What you probably are aware of, one of the most well-known examples of the difference between the U.S. system and the Thai system is the use of the jury trial in the U.S. And the jury trial allows for the decision-making process in a criminal trial to be made primarily, at least in terms of the factual decisions, by a jury of one's peers. Peers means somebody that's at an equal level to the defendant. What that means in practical terms is that jurors are not judges. They're not necessarily judges. They're citizens. They can be judges or attorneys, but those judges and attorneys, once they're on a jury, they have the same rights and duties as every other citizen. So that's important to the U.S. system because the U.S. system believes that in order to have due process, we can't have just a professional class of adjudicators and judges. We have to have participation of the citizenry to maintain a check and balance between the public and citizens and the professional judiciary. A lot of you, many years ago, the very famous court decision was the O.J. Simpson decision, where O.J. Simpson was accused of murdering his wife. And he went through a trial, and it was very controversial. The jury selection process lasted weeks, if not months, a very, very long period of time, and he ultimately won the case, which caused a great deal of controversy. These are the type of trials that Stuart Leeds is involved in on a regular basis, very serious, major criminal trials. The second major difference, besides jury trials, between the American system and the Thai system is what's termed as motion practice. A motion kamrong is a document filed before an actual trial. And it's a very important part of American practice. It enables the defense attorney representing an accused person to file various requests with the court to strike evidence, to prevent evidence from coming in, or to have a case dismissed, or for various other remedies or corrections to the system because the defendant's rights have been violated. So you can have motions based on a violation of speedy trial, which means they're not bringing the case, the court is not bringing the case to trial fast enough because there are specific provisions that a person that is accused of a crime has a right to be brought to trial within a certain amount of time. Normally that's 180 days. Now, most of the motions that are very successful, usually, and that defense attorneys file regularly, are motions based on the Constitution and particularly the Fourth Amendment. The Fourth Amendment is the amendment of the Constitution that has to deal with the right of a person to be safe and secure in his homes and his belongings. That means that your home or your private property in a car, the government, the police, or various administrative agencies cannot go into your property to search or to seize property without probable cause and without a warrant. Now, I know in the Thai system, there are also warrants required and also probable cause required. The key point of the U.S. system is that if a police officer or a member of the government that's involved in an investigation violates a person's rights to search and seizure under the Fourth Amendment of the U.S. Constitution, the evidence is excluded from the trial. That means the defendant might be guilty in fact, but because the police did not follow the proper procedure, the evidence will not be used at trial, and therefore in most cases the case will be dismissed. This is called the exclusionary rule. Many of you have also probably heard of fruit of the poisonous tree, a fruit on a tree. So in other words, if the tree is infected, all the fruits that grow on the tree is also infected. So anything that results, any evidence that's produced by the government as a result of an illegal search can be excluded from trial, resulting in a dismissal of a case. The reason for this rule is because many years ago, we did not have an exclusionary rule in the United States. What would happen is that if a police violated a person's rights in seizing evidence, the police might be disciplined. He might have a fine. He might be subject to disciplinary procedure, but the evidence would still come in. So the Supreme Court determined that if this is how the Fourth Amendment is being asserted, it's not effective because it's not an effective protection for a person's rights against illegal search and seizure. So they created the exclusionary rule. A third major difference is major feature of the U.S. system is double jeopardy. That means the prosecution has one bite at the apple. That's a common American expression, English expression. That means they have to, if they're going to prosecute somebody, they have to do it right the first time. If they mess up the case, even if they don't mess up the case, if they present the case, even if it's well done, but they lose, the government loses, the prosecution loses, they don't get a second chance. It's over. Another key feature between Thai criminal trials and U.S. criminal trials is that in Thailand, when a witness presents testimony, the testimony is recorded, but it's the judge in the trial that summarizes the statements of the witness, the testimony of the witness. So therefore, what's presented is a condensed version based on the judge's recollection and understanding of what the witness said. In the U.S., it's completely different. A court reporter in the U.S. Records every single word said, not just by the witness, but by the attorneys and by the judge. Now, an attorney can object and say that's improper. I order that stricken from the record, which means that something violated the regular procedure, the normal legal procedure, and should not be used in a trial. And therefore, the attorney, either the prosecutor or defense attorney, will say, I want that stricken, which means that it will not be considered evidence. Nevertheless, even though the judge may grant that motion, that request, and say, we're going to strike that, we're not going to use that in the record, the court reporter will still include all the statements and the ruling that the judge has stricken that. So nothing can be hidden or nothing can be pushed out. Everything that goes on in a court, every word said, every motion requested, is all recorded, and an attorney, prosecutor, or defense can use that on an appeal. A fifth difference between the U.S. system and the criminal system is the vast majority, as far as I know, all of the U.S. jurisdictions, all the 50 states and the federal, do not allow private criminal prosecutions by individual citizens. A private individual can file a complaint with the police. A private citizen can file a complaint with the prosecutor or the attorney general, the person that's in charge of prosecuting. But in Thailand, you have something that we don't normally have in the U.S., which is the right for a person aggrieved by, who's a victim of a criminal defense, to file a private criminal action, asserting the criminal law in his own name. In the U.S., in virtually all cases, only the government can file criminal actions against an accused person. The use of the common law system is another very distinct feature of the U.S. system. The common law system, or a system that's primarily based on the common law system, means that the judge's decisions become law. Now, I know in Thailand, the judgments of the Supreme Court are used frequently. In the U.S., we have acts, we have procedures, but we also have case law. So case law is the judges of decisions. The judge's decisions, which are recorded and preserved in books. So when an attorney does research to defend a client or to prosecute a client in the U.S., you will look at the particular statute, you will look at the penal code, but that's only showing you just the first stage of the law involved. You have to research all the case law, all the decisions that interpreted that particular statute. And it's not just the Supreme Court opinions. Any court of record in the U.S., including local government, city-level courts, county-level courts, appeal courts, even courts from out of state, can be used as law to argue your case. You can use cases from out of the state if they're relevant. The difference between various types of cases, a Supreme Court case would have more weight. It would be more evidence-worthy than a lower court case. But even a very low-level court, a district court, at a city level, at a county level, that is legal precedent in the U.S., and you could use the decision to argue the case in favor of your client. You might not win, but that's valid law. So the primacy, the importance of judges' case decisions can't be underestimated in the U.S. system. The only body of law that has more importance than case decisions is the U.S. Constitution, or in some cases, the state constitution. That's the number one law. Finally, one of the key differences and one of the key features of the U.S. system is it's a federalist system. It's a very difficult concept to explain and to communicate, and it's very, very unique to the U.S. system. When the U.S. system was founded, it was founded with 13 colonies that eventually became 13 states, as well as a national government. So we have at least 51 jurisdictions in the U.S., actually more because we have territories. So, and we have the District of Washington, D.C. as well. So we have more than 51 jurisdictions. So we have one national government, the federal government. Most of you have heard about President Obama and the U.S. Congress and the U.S. citizen of the U.S. Congress, the U.S. Senate, the U.S. House of Representatives. What might not be very clear, though, is that that's just one aspect of our government. Every individual state has its own government. We're from Texas. Texas is a separate government, a separate court system. New York is a separate government, a separate court system. Most criminal cases are adjudicated at the state level rather than the federal level. But the federal level is also very active. Often there's conflicts between federal jurisdiction and state jurisdiction. So that's a whole body of law as the conflicts between state jurisdiction and federal jurisdiction and what will prevail. The U.S. Constitution was drafted in 1787, and it was ratified the next year in 1788. So we're well over 200 years of having the same Constitution. So it's a very long-lasting Constitution. There's been amendments to the Constitution. There's been court decisions interpreting the Constitution to clarify its meaning. But we have the same basic Constitution that we've had since the founding of our nation, the United States. I don't think it can be understated the importance of the U.S. Constitution to the U.S. justice system, to the U.S. political system, and to the social fabric of the U.S. as a social order and as a nation is extremely important. To understand the U.S. Constitution, we should look at it in historical perspective. The U.S. was founded on a revolution against Great Britain. The revolution was started officially by a document called the Declaration of Independence in 1776. And the Declaration of Independence and the U.S. Constitution should be viewed together as complementary documents that should be understood together, and each one clarifies the other. The revolutionary thought that the founders of the U.S. instituted in the Declaration of Independence is the idea that civil rights, citizen rights, are not granted by the government. The revolutionary thought process that stated very clearly in the Declaration of Independence is that people, no matter how rich or poor, no matter what their profession, no matter what their station in life, have innate rights that are granted by God. This includes some of the rights I've been talking about, such as the right to be safe and secure in your home and in your possessions, the right to freedom of speech. This is a fundamental difference between other political systems around the world. The basis of the American system, as a result of rights being intrinsic to humanity, leads to the conclusion that since the rights of the individual are always more important than the dictates of the government, that the purpose of the Constitution is to control the government from abuses against the public, rather than having a constitution that states that citizens only have rights because the government grants them or gives them the rights. Now, over the years, there's been a number of case decisions and amendments to the Constitution that have clarified it. And some people believe that much of the spirit that I just described about the nature of the U.S. Constitution and the U.S. Declaration of Independence has been abrogated, and that we need to get back to the original principles. But nevertheless, the U.S. Constitution in its entirety, is still fundamentally unchanged from the time it was written and ratified in 1787 and 1788. The Bill of Rights are considered the first 10 amendments of the U.S. Constitution, and most of the rights that become activated or that a criminal defense attorney will use to defend an accused person or defendant are found in the Bill of Rights, which are the first 10 amendments of the Constitution. Now, calling the Bill of Rights amendments is actually probably not the most appropriate term or the best term to translate it, because an amendment means a correction, that something's wrong in most common language. But in the case of the U.S. Constitution, the Bill of Rights, the first 10 amendments, are not corrections to the Constitution. They're a codification memorializing the inherent rights that every person has according to granted to them and recognized, not granted to them, recognized by the government. The key rights and amendments that I'll be talking about today are the Fourth Amendment, dealing primarily with search and seizure, the Fifth Amendment, and the Sixth Amendment. And there are more rights that are also involved, but we have a limited time today, and I think that those are the most important. The basic requirements for a search and seizure, and let's distinguish. A search is to go into someone's private property or even somebody's personal body, such as by blood tests, the various tests, or DNA tests. The seizure is the taking of those items to be used in a criminal case or to be forfeited to the government. So there's the search and the seizure. What the Fourth Amendment says is that before a government agent, whether it's a police, a prosecutor, a court, can take property or search property, they need a warrant from a judge, and the warrant needs to be based on probable cause, which means that they have to have a good reason. The government needs to have a good reason based on facts that a reasonable person can read and examine and say, that's reasonable, it appears to be a crime is being committed here. So anytime there's a search or a seizure, whether it's of a person's house, of a car, or of his personal body, a criminal defense attorney will normally file a motion to have that evidence excluded if it appears that the government has not either obtained a valid warrant or that the warrant is not reasonable and based on very clear and convincing evidence that it looks like a crime. It appears that a crime has been committed. Now, in the practical world, all of these provisions have been qualified so that the police and the government can have a practical basis to go about their day-to-day investigations, arrests, and prosecutions. So there's a number of exceptions to the warrant requirement of the Fourth Amendment. One of those exceptions is if the police officer sees the crime being committed in front of them. If he sees the crime being committed in front of him, generally he does not have to obtain a warrant to arrest the person and seize whatever property is involved in the crime. Probably in the majority of cases, however, the police will obtain a warrant, or the government agency will request a warrant after an investigation and not witness the crime as it occurs. So the warrant requirement will normally apply. The second significant exception to the warrant requirement is exigent circumstances, which is probably the easiest way to explain emergency circumstances. We suspect, the police is saying, we suspect that a crime is being committed. In order to prosecute the crime and bring the person to justice, we need that evidence. We're not totally certain. But the problem is the accused, the person we suspect, the suspect, is destroying the evidence. He's burning, he's putting it in a fireplace, he's taking it he's feeding it to his dog. In that case, the police will have an exception. I had to go in there because I saw him committing the crime. He had whatever illegal, drugs, contraband, weapons, and he was destroying it. And if we can't allow him to do that, because the case would be gone. The Fifth Amendment primarily deals with the right against self-incrimination, which means that when you're in police custody or government custody or in a court of law or any type of situation where there's a potential criminal action being filed against you, and you're in the presence of a government official, you have the right to not testify. So this means when the police or the investigator or a judge is dealing with an accused, before they can take a statement or interview that person, they need to apprise him of what's called the Miranda rights and his right to Fifth Amendment, that he has a right not to give testimony that would incriminate himself. No person under the U.S. Constitution can be forced to be a witness against himself. That's the Miranda rule. Okay, there's other aspects to the Fifth Amendment, including the right of due process and double jeopardy, which I discussed a little bit before. Due process is before the government can take life, liberty. They have to, right of confrontation is the Sixth Amendment. The Fifth Amendment comes into play in the court where you'll have a decision that a criminal defense attorney must decide whether to put his own criminal, his client, the accused, on the stand to give testimony. So this is often a very crucial decision for the criminal defense attorney and his client to decide whether you're going to have the client or the defendant testify. Frequently, usually when a police officer or an investigator takes testimony of someone accused of the crime, there'll be a written transcript and there'll be a recorded transcript to prove that the police or the investigator or the government officer apprised the person of his Miranda rights and his right either to say nothing or to request an attorney to assist him. Deals with the Sixth Amendment, and I think since Stuart Leeds, his presentation will be primarily addressing his role as an active criminal defense trial lawyer, that he's going to be speaking about this extensively in practical terms. So I'm going to be relatively brief about the Sixth Amendment. But the Sixth Amendment provides the right to the jury trial and the right to confrontation. The right to confrontation is if there's evidence against you that a citizen that's accused of a crime has the right to have the witness against him cross-examined to know who that witness is, and to have his own attorney cross-examine the witness against him by his own attorney in a court of law, so that the court can determine whether the evidence against him and the testimony against him is legitimate. There's no secret witnesses allowed under the U.S. Constitution. If somebody wants to provide evidence against you, he needs, and sometimes his attorney will have to require, that witness needs to be produced, and the defense attorney will cross-examine that witness. The part of the Sixth Amendment, including the protections to fairness, is the right to competent legal defense. So a person that doesn't have money for a private attorney in the U.S. is called indigent. If you're indigent and you're poor in the United States, you have a right to have the government appoint you a free attorney that the taxpayers and the government will pay for. So in the practical terms, this means that there's often a whole agency or office called the Public Defender's Office in cities and states that do nothing but represent people that do not have money for their own private attorneys. That's all my talk today. We're going to have the discussion afterwards. And just okay, so I'm going to introduce Stuart L. Leeds. He's just completed a kidnapping trial in Texas that he won. His client was acquitted. He's a very prominent attorney and has completed hundreds of trial cases and hundreds of jury trials, both as a prosecutor and as defense attorney. So he's the real deal. He's in the courts every day for over 30 years. I know he looked much younger. It could only be about 10 years. Okay, so Stuart Lee.